Welcome, everybody. I'm Adam Hopler with the law firm of Hopler, Whelms, and Hanna. I am here with Kate Anders, and we are going to be talking with you today about the fundamentals of estate planning and IRAs, a very riveting, lively topic that I'm sure everybody will find immensely amusing. Kate, how are you doing today?
I'm great. Hope you are.
I am doing all right. I think a good place to start might be just a little bit about ourselves so people know where this information is coming from. Kate, tell us a little bit about who you are, how you got to what you're doing, and maybe even where you're at right now and how things are going.
Okay, great. So I am a financial advisor with Principal. This is my actually 10th year anniversary was last month. 10th year of being a financial advisor. So I've been around the block a little bit, and I graduated from Campbell University, go Camels, and I studied trust and wealth management there, and I also got my MBA from Campbell. So shortly after graduating, I went off into the real world, started working as a financial advisor with the previous firm, and switched over to Principal early 2018. So been at Principal ever since, and really enjoy what I do. Get to enjoy working with people, helping them figure out their financial lives, kind of putting all the pieces of the puzzle together. And then so I get to meet awesome people like Adam and the folks at Hopler and Whelms and Hanna that help out with my clients as well. So
excellent. Well, let's see here. What kind of hobbies do you have that have survived COVID-19? What sorts of things do you amuse yourself with the time that you have at home and things of that sort?
Yeah, I really enjoy baking, which has become quite the trend over COVID-19. Probably cooked a little too much. And let's see, I'm like an HGTV junkie. I love it all. I think I can do it all, and I'm not very good at it, but I like to think I am. So definitely probably watching a little too much Netflix these days. I do like to enjoy, I enjoy reading in my free time as well. So yeah, lots of indoor activities these days. So
excellent. Yeah. Got to watch out for that HGTV. I know my wife gets all kinds of ideas up in her head, and it's like, maybe we should rest with normalcy, but maybe not. But well, very good. I guess just I will reciprocate a little bit just about myself. So I've been, I think, practicing about the same amount of time that you have, Kate. We started 2011, so we're not quite at 10 years yet. I've been doing primarily estate planning with this law firm with my partners, Chris Whelms and Peter Hanna. I am primarily in Durham, but our practice is in various surrounding counties, Orange, Wake, etc. We kind of in that realm of estate planning, helping people out with wills and trust and dealing with the contentious issues that come about with them when family members pass and having to put those things into play. I'm married. I have way too many kids, and that's pretty much alleviates for me from having any forms of hobbies. I mainly just chase after mine, and whatever it is that they enjoy doing, that's what I enjoy doing for the time being. I suppose if I ever get free of that, I might go skiing or something, but that's just a dream in the future, something to motivate me as I sit here in my office every day. I guess maybe kind of on to our topic a little bit. Oh, and let me kind of make a quick note for folk. We do have a comment section over on the side. So I've taken the liberty of putting a few things up there so you can see website, for instance, for myself and Kate, so you can learn a little bit more about us, learn a little bit more about our companies. If you have questions that want to follow up after this presentation, those would be good places to start. So feel free to take use of the comment section, though, to make comments or to ask questions. We are going to allocate some time on the back end of this to try to entertain the fielding of those things that y'all make in the side over there. We may not be able to give direct responses throughout the presentation, but we will try to address each question, even if to give like a very lawyerly, it depends or something, but we'll address it in some way to make sure that we can give you some guidance as we go forward from here. But primarily, if you have personal things that you're looking to deal with, those are probably going to be better addressed individually through discussion with either myself or Kate as appropriate. But again, generic questions are probably where is going to be most appropriate for this setting. So that'll be up there. But with that, Kate, I think for our format today, you're going to give us kind of a rundown a little bit about retirement accounts. That's a pretty broad topic, IRAs, and what they are, how they work. I think throughout today, you and I are both going to be talking a little bit about this Secure Act and some of the things that it's done to modify the way things used to be. Some folk may have an appreciation for that. Others may be like, I don't even know what things were like before the Secure Act. And so, we'll kind of leave that in our respective discretion. But yeah, I guess if you want to just kind of kick us off, give us a start about what is this topic? What are IRAs? How do they work and things of that nature? Yeah.
Yeah, definitely. All right. Thanks, Adam. So I thought we would start by talking about a little bit of a misconception that I see a lot with my clients. And I imagine, so if that's, a sampling of the general public, that this probably is a misunderstanding overall. So that a qualified plan and a tax advantage plan, although they have the same end in goal, which is saving for retirement, they are very different. So a qualified plan is usually what you think of that your employer offers. So think of like a 401k, think of a pension plan. Those are going to be qualified plans. Those are governed by ERISA laws, which is a whole other topic for another day. But those plans are usually offered through your employer. They can be either what we call defined contribution, where you put a set dollar amount of your paycheck into the plan and it grows. Most of you have seen that with a 401k or something similar. Or it's a defined benefit plan where there is money going into it, but you're guaranteed some kind of monthly benefit in retirement. We see that a lot with state and federal employees, and some other companies also still offer a pension, but that is qualified plans, which oftentimes is misunderstood that IRAs and 401ks are the same thing. Mm. So tax advantage plans is a broader spectrum when we talk about IRAs. When we look at IRAs, there's 4 or 5 different kinds. They all work a little bit different. The people who can use them is a little bit different. But that's kind of the basic of today's presentation, is talking about IRAs and really how they affect your family's future. So IRAs, yes, they are very similar to qualified plans in that they have the same end result. They're just a vehicle in which we save for retirement and hopefully get to enjoy retirement. The big difference, they're held on an individual level. So they really, you'll often see with a 401k that it says ABC Corporation for the benefit of John Doe or something. The company is technically the owner of that account and you are a participant in it, versus an IRA where you are the owner and it doesn't really have to do with your company. So they're held on the individual level. They do have much more flexibility in regards to investment choices. So you have, you can pick through tens of thousands of mutual funds, through ETFs, through stocks. You can even, just use like a money market cash vehicle in your IRA. There's a lot of flexibility, which gives us some variety when we're talking about specific to each individual, what their risk tolerance is, what their goal is. We can really custom make that in an IRA versus a 401k or a qualified plan. You're usually limited to just about 20 or 30 choices that's in the plan, and that's all you have. So, with the IRA, you do have a lot more flexibility, but with that flexibility, they also have some more restrictions on them. So although most people can contribute to a traditional IRA, not everybody can deduct that contribution, which kind of negates the point. There's also some income level eligibility, like with Roth IRAs, that if you make over a certain amount, you can't contribute at all. So, just knowing kind of the rules around those, of which a financial advisor can help you with, making sure you're making the best decision as to where you're saving in the most efficient way. There's also, in the category of IRAs, there's steps and simples. Step IRAs usually see with self-employed folks. They offer a much higher limit as to how much you can contribute, but they're only available for usually self-employed people, or maybe somebody who just has 1 or 2 employees. And then you have simple IRAs. Those are usually seen in the small business field. Usually maybe a business owner who has less than 20 employees. A simple IRA can be a good route to take. But all that being said, they're all under the category of IRAs. Therefore, they are a vehicle in which you save for retirement, and you have to think about beneficiary planning and how you want to go about that. So, if we have all these qualified plans, we have all these tax advantage plans, when do we use what at what phase, how much do we use it? And a lot of that depends on where you work. So if your employer offers some type of plan, maybe with a match, you'd be stupid not to take that, right? That's, guaranteed return on your money, because if you're putting in 3 and they're putting in 3, that's great for you, because that's 3% you wouldn't get otherwise. Whereas in IRAs, they don't have matches, unless you're using maybe a simple with a small business owner. But for the most part, it's what you put in, it's what you're putting in. So I often tell my clients, if your employer offers some type of match in that plan, definitely take advantage of that. And then maybe put the IRAs on the back burner for another day. That doesn't mean that they can't exist, but you don't need to be contributing to them. A lot of that depends which one do we use if we're a small business owner, if we're self-employed. And that comes back down to where you work. How do we just make sure you're taking advantage of those, and a good financial advisor can help you figure that out. Another big factor in which one to use is, are you trying to put away the maximum amount per year? IRAs have a much lower contribution amount. If you're under 50, you can put $6,000 into an IRA, versus when you're in a 401k plan, if you're under 50, you can put $19,500 away. So they do have limits on how much you contribute. So if you're really trying to put away the much as you can, it might be better to look at more of a qualified plan versus an IRA. And then keep in mind too, if you retire, if you leave that job, God forbid you become disabled, those are all times in which money can be moved from a qualified plan to an IRA. So it doesn't mean that once you're in one, you're stuck there forever. They can be moved, they can be transferred when qualifying events happen. So keep that in mind. That's also just a good idea, a good reason to keep in touch with your financial advisor, let them know about big life changes that are happening, so they can kind of walk you through those steps. All right, so next let's talk about, under the category of IRAs, we got different kinds, right? And they're all taxed a little bit differently. So in the world of investing, you have taxable accounts, you have tax-free accounts, and you have partially taxable accounts, okay? And that's really talking about how it's taxed in distribution mode during retirement, okay? So when we're talking about traditional IRAs, this also includes steps and simples, because they're all under that pre-tax umbrella. Traditional IRAs are going to give you a deduction in your current tax year. Okay, so let's say, for example, Joe Smith makes $100,000 in 2020. He decided to put $5,000 into a traditional IRA. And assuming he meets all the criteria for being able to contribute and be able to deduct it, on paper, he's really taking that $100,000 and making his income $95,000. Okay, so he's reducing his taxable income in the current year, which is great if you need that, right, in your current tax bracket. The flip side to that is when you do retire, so let's say 25 years down the line, Joe Smith retires, that money has grown, most likely, from what it started as, either from market growth or from him contributing. That money is now going to become taxable when he starts pulling it out. So he'll be like punching a clock every day. So that's going to be at his ordinary income bracket. When we talk about Roth IRAs, they're the exact opposite, okay? So let's say, once again, Joe Smith makes $100,000 in 2020, and he puts $5,000 into a Roth IRA. On paper, he still makes $100,000. He's not going to get that deduction, reducing his taxable income. But the cool thing is when he retires in 25 years, all that money is going to have grown over the past 25 years, and it's going to be pulled out totally tax-free. So especially when we start talking about our younger investors, that can be a huge benefit because there's so much time in which compound interest can really be your best friend and do some good things for you. So Roth IRAs are a great opportunity, especially if it works out with your timeline and with your family dynamics when it comes to taxes. Caveat here is not everybody can contribute to a Roth IRA. So they do not care if you are covered by a workplace plan like a 401k, which traditional IRAs, that becomes a little sticking point. With Roth, it's just if you are single, if you're filing your taxes single, you can't make more than $137,000 in 2020, and married filing jointly is $206,000 combined. So if you're over those limits, then Roth IRAs are just not going to work for you. We have to look at other options. And if you're really close to that number, like within 5 to 10,000, make sure you talk to your tax professional or your financial advisor, because there's a phase out range, they call it, in which you can't do the full amount. So you just want to make sure that you're playing by the rules and only contributing what you can to that Roth. So just make sure you're aware of that. There's also this other animal called partially taxed accounts. Investments, you could have the exact same portfolio in a Roth IRA and a traditional IRA, and then maybe a non-retirement account, right? All they are is buckets, and you can put whatever type of investments in them you would like. But with these partially taxed assets, there's stuff that is taxed on the gain at a capital gains rate, okay? Capital gains for the majority of people, the largest bracket is a 15% rate. So, and it's taxed on the gain. So that's meaning, let's say you put $10,000 in, it grows over the years to $15,000. You have a $5,000 gain there. So when you pull out that $15,000, that $5,000 gain is going to be taxed at 15%. So for most people, that's lower than your ordinary income bracket. So that's nice. You know, a lot of people do this because they're maxing out their retirement accounts. Another reason they might want to do it is they don't want the rules about when and how I can pull out my money. So like with IRAs, we have some rules about pulling it out too early, you'll get penalized because it isn't for retirement. So, you know, with these non-retirement accounts that are taxed partially, you know, we get rid of some of those rules, and it might just be a good fit for that client, that they have some more flexibility and they don't have to account for when and how they're pulling their money out. So that's an option as well. And then when we're also talking about pre-tax and after-tax, this traditional versus Roth, and you're saying, well, hey, I have money in traditional IRA, but this Roth sounds really appealing. There's a point in which you can convert it, correct? So if you are okay with going ahead and paying the taxes in the current year, then you can go ahead and convert to a Roth. You need to work with your tax professional when doing that to make sure you do it correctly and make sure you're paying the appropriate amount of taxes. But it's a great opportunity to maybe take advantage of some of that tax-free growth that you can get in a Roth. So definitely, if that interests you, I definitely talk to your financial advisor and your tax professional, and looking at Roth conversion. Okay. And then, so when we talk about IRAs, there's two life cycles, if you will, to retirement planning. There's your contribution mode, in which obviously this is most of your working years, in which you're contributing, you're putting money away for that retirement day that hopefully is coming sooner rather than later. And then you have distribution mode. And distribution mode is obviously taking the assets out of retirement accounts so you can enjoy retirement. And also, as we get a little bit older, we want to make sure that we have proper beneficiary planning in place. So it's just I like to break it up into kind of two separate life cycles and talk about them differently. So let's talk about contribution mode to begin with. So like I said, this is mainly during your working years, in which you're stocking away money for retirement. So let's talk about kind of how long you can contribute and then how much you can contribute. So as long as you're working for an employer who offers a qualified plan, like a 401k or something, you're eligible to participate in that, assuming you meet their eligibility requirements. So I would definitely take advantage of that, like I said priorly, if there is a match. A 401k or something similar has a max amount of $19,500 for those who are under 50. And then if you're above 50 and above, you can contribute actually $26,000 to that. This is in stark contrast to IRAs, which IRAs have a $6,000 contribution limit for those who are under 50. And if you are 50 or above, you can do $7,000. So it is much smaller max amounts that you can put into IRAs. But once again, it just depends on what you're trying to accomplish, how much you need to save. Maybe is your spouse doing the same, working as that together. So the cool thing, and we're going to talk a little bit more about the Secure Act in a little bit more detail later on. But, not that long ago, 2019, you weren't able to contribute to an IRA past 70 and a half, a traditional IRA. So that has actually gone away now with the Secure Act. So you can contribute any age as long as you have earned income. So if, let's say you are 72, and you have a little side gig that gives you $10,000 worth of income a year. So you technically could put the full $7,000 into your IRA if you wanted to, because you have enough income to show for that. So as long as, if you wanted to put $7,000 away in an IRA past 70 and a half, as long as you have $7,000 worth of income to show, you can do that. So that was a nice little goodie that the Secure Act threw us. And then if you do have simple IRAs or SEPs, those are a little bit different. They do have higher contribution limits. But once again, you have to talk to your tax professional, talk to your advisor, and see if that qualifies for you. And then, so we've done all the saving throughout our working years. Now we get to the fun part, right? We get to retire, we get to enjoy life. So we go into distribution mode. This distribution mode, it looks different for a lot of different people. Some want to keep working, maybe in a side hustle kind of thing. Some people don't ever want to work another day of their life. They want to travel the world. So whatever it is, however that retirement looks for you, it's very likely that you'll have to start taking funds out of your IRA for one reason or another. You do get to the point at 72, which is also a new rule from the Secure Act. It used to be 70 and a half. So at 72, the government is going to require you to take what's called a required minimum distribution. A required minimum distribution, you're like, they're going to make me take money out of my accounts. And the reason behind that is, this is a tax deferred account. Once again, we're talking about traditional, so the pre-tax vehicles. If they've never been taxed, right, the government's saying, all right, well, it's time. You're not a spring chicken anymore. And we're going to start making you take a small amount out so we can get some of the taxes off of that account. Okay, so they want to start collecting their fair share, essentially. So they calculate your RMD, required minimum distribution, off of a life expectancy table that the IRS puts out. So, and they also use your end of year value from the previous year. So they calculate this number, let's say it's, I don't know, $5,000. They're going to say, all right, you got to take $5,000 off for 2020, for 2021. That number likely goes up a little bit every year. Now, this Secure Act came about in December of 2019. So we roll into 2020, and then, as we all know, COVID-19 happens. So then they passed what's called the CARES Act. Many of you know the CARES Act because of the stimulus checks that came out, some of the help that went out to small business owners. The CARES Act also provided a provision that said, okay, for 2020, those RMDs that were required, we're going to waive that for 2020. And the reason behind that was, if the market has taken a tumble, which if any of you were watching the news, you saw that if the market took a tumble, we don't want you to have to take money out when your accounts haven't had a chance to recover yet. So that is only a one-time thing. I am, in the 10 years I've been doing this, I haven't seen them do that before. It's highly unlikely that that becomes a regular thing. Extraordinary circumstances, of course, with COVID-19 and the effect it's had on our economy. So to know, in 2020, you do not have to take an RMD. And that also applies to if you inherited an IRA that required an RMD, you also do not have to take that as the beneficiary IRA. So, like I said, with the Secure Act, RMDs are at 72 now. So 72 and above, except the exception of 2020, we have to start looking at those RMDs. And then, unfortunately, people pass away before they get a chance to enjoy their full retirement. So we have to even think about required minimum distributions after death and how your beneficiaries are going to take that. So prior to 2020, not that long ago, non-spouse beneficiaries had the option to take the IRA, keep it in a tax-deferred account, and only pull off a minimum amount, a required minimum distribution. That was awesome for them because they got to keep all that tax. Instead of inheriting one lump sum, they would just pull off little pieces, therefore not making any surprise tax bills. So with that, the Secure Act that passed, they limited how much we can stretch that IRA. So instead of being able to stretch it over a full non-spouse beneficiary's lifetime, we have to stretch it over a 10-year period now. So, that has provided we need to be a little more creative in our beneficiary planning, which Adam is going to talk about in a few minutes. So that's worth noting that that's a big, big change that happened with the Secure Act. So 10 years is a lot different than stretching it out over your entire lifetime. It should be noted too that it's a little bit different for spouses. Spouses have a few more options than non-spouse beneficiaries have. Spouses can take like an IRA and put it in their own name, and then it just follows the regular start taking RMDs at 72 rule. So spouses have a little more flexibility, but when we start going to a non-spouse beneficiary, like a kid or a grandkid or a sibling, that's where you have to be careful about stretching it out. So with that, we have to be a little more creative in our strategies in this distribution mode. A lot of times I'm seeing with my clients now that they're really worried about their son, their daughter, their heirs inheriting an account that they have to pull out within 10 years. They know that tax bill is going to be really hard for them. So now they're thinking about, well, I'll spend down the retirement assets in my golden years and leave some of that non-qualified money that doesn't have those strict rules to my beneficiary. So it's really changed our distribution mode strategy when talking with clients. Roth conversions are becoming more and more popular because although a Roth IRA still has to be distributed within 10 years after death, because there's no tax liability, it can be all flown out in that 10th year, which is kind of nice. So we're seeing a lot of Roth conversions. And then an even bigger part is we're seeing a lot more creative estate planning strategies. And that's where I really like to use attorneys like Adam and his partner, Chris, to help with, okay, well, how do we do this in a more effective way that we have more control over it, even though we've passed? So with that being said, I'm going to kick it off to Adam so he can talk a little bit more about some of those strategies and how he works with his clients with them.
Excellent. Well, that sounds good. Kate, thanks so much. That's quite a lot to try and cram all that into a little bit of time. But if anything, I hope that folk are kind of taken from that, that there is a lot of nuance, a lot of complexity, that it's not just an easy one size fits all type approach. And so definitely encourage folk to take time to follow up on questions that may have been spurred from the various things that Kate has covered with us. I am not a financial advisor, and so I will oftentimes have folks that come to me and talk about things, and there are definitely going to be times where I'm going to say, you know what, we need to involve somebody else that can talk to us about the nuances of different types of accounts, tax advantages, and things of that sort while you're alive. Because most of what I'm focused on is when you're gone. And so with that, I want to, quickly, I guess, cover what are the critical estate planning documents, so that we at least have some ground level of our discussion. And then I'm going to try to focus most of my time on the crossover, if you will, between estate planning, IRAs, and some of these new law changes that have come about recently. So we have in focus last will and testament. This is the document that I think most people are familiar with, may not necessarily understand that all that goes into it. But we also have powers of attorney. And in North Carolina, we divide these into two basic camps. We have a durable general power of attorney, which there's a lot of reasons why it's labeled that way. But in essence, I think it helps to understand it as a financial power of attorney. And then a healthcare power of attorney, which is separate, and it just deals with the person, medical decision making. Then we have a living will or an advance directive, and it is basically, it's similar in that it's a statement of desire, which is why we call it a will, but it is very different from a will. It has nothing to do with it. It's not a granting of a power to anybody. It is truly a statement of desire by you in a very specific circumstance. And then lastly, we have this idea of a trust. And so we're going to kind of talk about that, but trust will be where we'll rest for our conversation as it relates to IRAs primarily. But a last will and testament, again, is focused exclusively for when you pass away. And so I say this a lot of times with folks, estate planning, what I'm doing has much less to do with you, the person that I'm talking with, than it does everybody around you. Every one of us is going to leave behind people that we love, that we care about. And one of the things that we can do as an expression of that is to help them in dealing with what's left behind. When we don't have a plan, people don't have answers, they have questions, there's uncertainty, ambiguity that can lead to fights, discussions, squabbles, confusion, anxiety. And so we want to alleviate as much as we can by saying, hey, this is what you do. And so in a will, we get to say, this is what happens to my stuff. We get to nominate a person to come in and follow those directions. We make it clear who's going to take that job on. We set backups for contingencies because we don't know what the situation will be when we pass, but we're going to give people a guide of what are the fallback positions. And so as an attorney, I'm helping to kind of run people through scenarios for that kind of thing. We talk about our children and who might care for them, both financially as well as like personally if they're under the age of 18. But that's exclusively, again, after passing. The documents that were called powers of attorney, those are primarily focused for while you're alive. This is a much happier scenario. You're not deceased. You are just disabled. So we're now going to deal with what do we do if you are in a position where you can't handle everything by yourself. We don't want to wait to that point where you can't handle things because it may very well be that you can no longer create the documents at all. And so if we wait to take care of these things, we're almost by surety guaranteeing that we don't have a plan in place. And so while you're able, while you're capable, while you don't have problems, you need to jump in and get this done. Because what it does is it says, if I can't handle things, this is who I trust. So we all now know who is the person that you would look to if you had a choice to take care of, as it with the durable general power of attorney, financial matters, real property, things that you own. We may grant really broad authority. We may narrow the authority depending on the circumstances. But when you need somebody to assist you in managing things while you're still here and present with us, that's what this document is for. The healthcare power of attorney, like I said, the flip side of that, exclusively medical decision making. And while with a financial power of attorney, you may go ahead and grant the authority for a person to act on your behalf while you're able to make decisions. And so you could say, well, I need you to go to the bank and take care of this, and that's fine. They would go do that. They would have the authority to do it. With a medical health care power of attorney, this one only clicks when you're incapacitated. And that makes sense because you're not going to send somebody to have your rash diagnosed or, explain a pain that you're having in your side to a doctor. No, you need to go and deal with your own medical decisions. And if you can make them, you should make them. And a doctor is going to be much more qualified than, say, a teller at a bank to discern whether you're able to make a decision or not, right? So if you're sitting there in a hospital and the doctor needs to get an answer out of you and they can't, this document would say, here are the people that doctor can look to make decisions next. We do have a statute that will replace this if you don't have one, but oftentimes it will use in various places kind of a committee approach. So if you have multiple children, for instance, the majority of your children, or if you have multiple siblings, the majority of your siblings. And while that is maybe fair, it can also lead to a lot of confusion. And, that's the last thing you want in an emergency or for ongoing care. So this is your time to say, hey, y'all, this is what I'm okay with. Go ahead and set this ranking in. The advanced directive, again, that document is a very nuanced situation about end of care decision making. You can't make the decision, but we need to know what are your prerogatives in terms of whether we can take a hands-off approach, or do we need to just ride on the Hippocratic oath, do no harm. They will do everything to take care of you no matter what. Or can there be a circumstance in which you might say, it's all right, it's time to go. And so this is a document that you weigh and balance. It's not a one-size-fits-all type thing. You have the opportunity to craft what your desire would be with this document. And so then finally we get into trust. And so this is where I'm going to kind of rest and mellow here for a little bit. The idea of a trust is that you can, at any time, take things that you currently have in your possession, and you can essentially give them away to another entity. That sounds a little scary at first, but when you think about it like you would maybe a business, for instance, people do this all the time where you create a business and you give that business stuff, computers that sit at your desk, real property, maybe vehicles to drive around a fleet, whatever it is. But the business itself will open up a bank account and maintain funds that come into the business and use that stuff for the business itself. The trust is very similar in that way, in that you can go ahead and fund it, and it can set up accounts, and it can own things, and it will have its own set of rules that you define. And so obviously you want to be very careful with how you define those rules. And so this is where you would speak with an attorney about how you draft that document to accomplish what it is that you want it to accomplish. So many times people will set this up in a way that it mirrors themselves while they're alive. So, if myself and my spouse create a trust, we're going to be the people who control that trust, that make the decisions about the trust, and that trust is going to benefit us. For all practical purpose, the things that are in that trust continue to be used in exactly the same way that I would have otherwise used it if it was in my name. The key factor here, though, is that when I pass and when both the spouses pass, there is not a transfer. Money does not change hands from one person to another. It stays right where it was with the trust. And now what we do is we essentially have a new boss, a new CEO, a trustee in our case, that takes over. So a trust really should be thought of as like a separate person. Now, let's kind of back up to what Kate was talking about with IRAs. I'm going to run through this kind of scenario here that you can see here to give us an idea. As Kate just discussed, when you have a retirement account and you've got, in our typical scenario, spouses, between spouse and spouse, that's the easiest transfer that we're going to have. We're going to go from one spouse, if that one passes, to the other. And unlike a lot of accounts that you may own, where you may set them up as like joint accounts, husband and wife on the account, that's not really something that you can do with an IRA or another 401k, 403b. Those are going to be in one person's name. And that one person is going to have a right to that account. And really the control that you have is setting your beneficiaries. Where does it go after you? And so if you still have money in a pot from a retirement account and you've named your spouse, and more often than not, if you have a spouse, that's going to be the heavy prerogative and you'd have to go through a lot of steps to do something different. It's going to go that direction and it's going to essentially roll over and it's not going to be treated all that different. And the spouse will just continue riding it under new terms as if it had been theirs all along almost. So that's pretty straightforward. There's not usually a lot of hiccups with that. But both spouses need to have in their mind a plan for what happens when both of us are gone. Because one way or another, even if both of them have accounts or only one of them has accounts, eventually once both of them pass, it's going to go somewhere unless they've just depleted the whole account. And that was one of the things Kate talked about. That might be your strategy, but that would need to be really thought through because, again, you're going to have ramifications about how much you pull out, what are the taxes and everything else. So let's just say for a moment that you do have something left over. What happens now? So in essence, you would have backup designated beneficiaries. And if in our scenario, you've got kids, it probably makes sense to you to go ahead and say child 1, child 2, child 3, and we're going to do even splits between each of them and we're done. And that's pretty straightforward. Now, as straightforward as that may sound, for some folk out there, you may be in the process of building your family. And you go and set up your designated beneficiaries when you have child number 1, and then you forget about that with child number 2, child number 3, child number 4, et cetera, et cetera. That's an issue. This has to be updated on a regular basis if you're going to continue to have children, because they will take it literally based on what you fill it out. So that's one thing to be thoughtful about. But even beyond that, as Kate was discussing, depending on what you're trying to accomplish and how your children may grow up differently, you may not want all of them to get an equal split. Maybe one child you're going to benefit in a completely different way. You're going to give them the house, for instance, or you're going to have a life insurance policy. And so you want to have this set up for 2 kids and not all 3. Those things have to be thought through very carefully. But when it comes to IRA distribution, what used to be the case is that you could, as Kate said, kind of drop it down to the kids. And if each one of them were named, they would essentially have their own account, and their own life expectancy is what you would be using to determine what the required minimum distribution was going to be every year. So as an example, child 1, child 2, child 3, if child number 1 is 15 with a life expectancy of, and I pulled this from a chart, it could be wrong, but whatever, 67.9 years. Well, okay, we're going to use that as a bench point for our math to determine how much does that kid have to pull out every year. Child number 2 is going to be a little bit older, so theirs is going to be ever so slightly higher. But what if you have a situation where child number 3 has a child of his or her own and is deceased, and you've decided to drop it to a grandchild instead? Oh, well, that grandchild is going to be much younger, and it's going to have a much longer life expectancy, and thus their required minimum distribution would be much, much smaller. So that is actually something that is interesting when it comes to planning. And you would say to yourself, ooh, I could get much more, stretch bang for my buck by giving this to my grandchildren instead. And so you might think to yourself, well, I'd like to see it last as long as possible for my future. So I'm going to use grandkids, and I'm going to give all this to them, and I'm going to give my children something else. These were things that you can kind of think through in terms of how this might work. But the essence is that you're dropping it to them and you're thinking about it. Now, as you look at these numbers, what should pop into your head is, wow, 15, that's pretty young. 20, ooh, that's pretty young too. I mean, technically they're adults, but only technically. Is it wise? Is it a good idea to give an outright distribution of potentially your life savings? Because it's not uncommon to run into folk that in their later years have stocked in a lot of money into a retirement account. And that, a lot varies. For some people, a lot is 200,000 or 2 million. For some people, a lot is 50,000 or 100. But either way, however it is that you think about being a lot, if you have a child and I'll say even a 20-year-old can be a child, but you have a young person receiving a lot of money, that's going to change the way that they think about things. And so you might want to maybe ease the transition, so to speak. How could you do that? Well, you could use a trust, right? Because you could give the money to a trust, and the trust would then have possession and ownership of it, and it could give it out with some guidance to the beneficiary. So you set rules that say, all right, yeah, I'm going to give it to my kids, but I'm really going to give it for the benefit of my kids. I'm going to give it to a trust, and the trust is going to be the one to make sure that my kids act responsible by doling it out in small doses. Because once they become the owner of the account, what can they do? Well, they can distribute as much as they want. And if they want to distribute all of it at one time and just pay a lot in taxes up front, they can do that. And that may or may not be a good idea. And so it's an interesting question as to what will your kids actually do if they get put into that situation? What would you have done might be a way to ask it. Because I can think back when I was in that age, and as responsible as I might have thought myself to have been, it would be very tempting to just take a lot of money right now instead of a little bit over a long period of time. So this is where the Secure Act sort of changed things up. Well, not sort of, it did. It changed things up a lot. And one of the biggest, I guess, modifications is that we can no longer give to a non-spouse beneficiary that lifetime extension, with a few exceptions, which are, kind of covered right here. In essence, they are now going to be limited to a 10-year period of time that they have to take that money out. Now, 10 years is still not insignificant, and the same calculus is in play. If you give, say, an 18-year-old the option to take $100,000 and pay, I'll just make a number up, $30,000 in taxes, and then they get $70,000 outright, or to take a small required minimum distribution over a long period of time, 10 years, right? So it'll be broken up into 10 incremental payments. Which one are they going to do? Well, it's kind of hard to imagine that that child might not just take $70,000. Whereas if they spread it out over 10 years, they would wind up with more money at the end than they would have otherwise. And so why not just take it slow? But that's a good question. So you can still utilize a trust to basically force that. Now, what the caveat here is that you need to be very careful about this, because if you give a non-living beneficiary this asset, well, a trust is a non-living beneficiary, it's 5 years. So you have to be very careful on how you craft that trust so that you get the benefit of the 10 years and not the 5 years. And so that's where attorneys will work with you very carefully to make sure that things are done the way they should, so you can get as much as you want. Just briefly, I mentioned that there are a couple exceptions to this. Obviously, spouse is an exception. We've talked about that. But if you have a minor child, say you pass and you have a child who's 15, we're not going to apply that 10-year rule until they're 18. So in essence, a 15-year-old can get a stretch of what appears to be on paper like 13 years. The calculus is not quite as straightforward, like take a 13 and divide by 13 or whatever. So that's something that your financial advisor would make sure that you're being met with. You pull for 15 to 18 a certain amount, but then that calculus will change when they hit 18. But still, you can get a little bit more of a stretch if they happen to be minor. And so you still, same concept, would want to have your trust set up so that either way, you're getting the maximum amount of time that you can for that child to take only as much as they have to, so that the pot continues to invest and grow over time. And then when they're 28, in essence, the entirety is now been distributed, and that child will have hopefully grown some wisdom in terms of how it's going to use that money at that particular time. Special needs children have completely different rules, which we're not going to be able to cover today, but you would be able to work out in a special needs scenario a much longer stretch period. There's a whole lot of discussion going on in terms of what types of accounts are ideal. As Kate talked about, the benefits of converting over to a Roth IRA in this type of scenario would certainly be something to consider. And then there's also an exception for folks that are not more than 10 years younger. And so if you're naming somebody as your heir, like a sibling, for instance, that's pretty close, they may be able to go ahead and use their lifetime distribution. But the key here is that you can use a trust to essentially force the slowdown. Because once you hand a beneficiary outright, you name them personally, it's up to them. They make the decision. And if you have a concern that the person may need some help in learning the wisdom of investing, a trust can be a way to really help out with that particular scenario. Just some definitions on the page here so you guys can follow up. That period of time that you have to distribute is that applicable distribution period. Who qualifies as being disabled or chronically ill. So with that, I will pause. And I would like to invite folk who are with us to take the opportunity to, ask some questions. I'm looking at one that we have here. Let's see here. It says, I have longevity on my side of the family, which is awesome. And my spouse does not. Should we plan to boost my IRA more than his to stretch out distribution? That's an interesting question. I have thoughts on that, but Kate, maybe what pops into your head when you hear that thought process in terms of IRA planning?
Yeah, so assuming that you would want your spouse to be your primary beneficiary, it's not as big of a deal because a spouse isn't limited by all that 10-year rules we were just talking about. You can rename, like, let's say your spouse does pass away, you actually have that opportunity to move that account into your own name. It would be like it was yours forever. It would have no indication that it was from a deceased. So if that's the case, it's not as big of a deal for assuming that you are the spouses are each other's primary beneficiary. And I would say keep it probably equal because life throws us some curveballs that we aren't expecting. So we would hate for, to plan for one way just based off of longevity and then it turn out a different way. But assuming, like I said, if your spouse is your primary beneficiary, it won't make that much of a difference because you're allowed to inherit that as your own.
Yeah, no, I think I would definitely agree with that. Too many scenarios that I've seen where you really are anticipating, this is the way it's going to go. Even my wife has joked with me that I'm not allowed to die before she does. So I don't know how I'm going to pull that off. But I gotta survive. You kind of make those plans. You feel like you have a sense of how it might work, but you really gotta assume that we don't know. And let's see here. Another one just popped up here. It says, is there a healthcare IRA or financial vehicle for healthcare expenses in retirement? And then the qualification is my healthcare premium is too high for an HSA, and I don't want a long-term insurance policy that limits a monthly amount for facility care. I'm going to defer on this one as well for a moment. So in terms of vehicles for healthcare expenses, certainly, my mind would have jumped to an HSA as a way of utilizing an investment potential, being able to stock up money for a long period of time, specifically for healthcare purposes. But what are your thoughts on that, Kate?
So if for whatever reason you're not eligible to contribute to an HSA, I guess my next question would be is, have you really looked into long-term care policies? Because that industry has changed drastically within even the last 5 years. There are so many different types of policies now. There's hybrid policies in which maybe if you do have a lump sum you can put in, like maybe you have some money sitting in the CD at a bank that's not earning much interest. You can actually take a lump sum, put it into a long-term care policy in which it still has a death benefit if you never need it for long-term care, but also as a multiplier that maybe it's 3 times that amount if you use it for long-term care expenses. So with that being said, there's a ton of different types of long-term care policy now. And some are not limited on that monthly basis. Like you mentioned an example of $3,500 a month. So there are some hybrid policies out there. If you can't use an HSA, then that's probably what we need to start thinking about. If you don't have good healthcare coverage in retirement. So
yeah, and I think it's a good question, but it also is great for highlighting, even as you kind of went through there, the calculus for each individual person, that you can look at your scenario and say, well, I'm not really looking to stay in a facility, or I've got family members that I plan on being able to lean on for long-term care, or having in-home care assistance or something to that effect, alternatives to different end-of-life planning. And so what you're aiming and hoping for and what you want to put your money into really can drive a little bit the kind of choices of what vehicle you're going to use for planning for some kind of care down the road from a healthcare standpoint. Because it's not going to be, again, one size fits all. There really is some thought and intention that needs to go into more than just having forms filled out, for instance. So no, that's a great question. Well, let's see here. We've got a few minutes left, and so as questions roll in, we'll definitely want to answer those. But yeah, Kate, I guess kind of thinking back on what we've discussed so far, were there things that popped into your mind that you said, "Ooh, I wanted to hit on this," or whatever? But yeah, any additional add-ons or supplements?
Yeah, so I would say the moral of the story, if you can call it that, this hour-long webcast, is that make sure, if nothing else, make sure you're updating your beneficiary forms and however they are. If they're as simple as a spouse and then a child, or if they need to be a little more complicated, including a trust, make sure you're updating your beneficiaries on the regular, once a year at least. And then if life throws you some curveballs in between those yearly check-ins, update your beneficiary. I mean, that is the single easiest thing that you can do. And it's not just your IRAs, your 401ks, it's your life insurance policies, it's putting designations on your bank accounts. These things are so simple, and God forbid something happens to you, it makes your loved one's life so much easier. So I guess if nothing else you take from this, just go and look at your beneficiary designations, make sure they're updated at the end of this.
Yeah, folk will ask me sometimes, like, how often should I update my estate plan? And so we kind of have a generic rule about, 3 to 5 years. You don't really want to wait too much longer than that. But honestly, I've thought about, even in my own life, the family reunion every other year, right? You go and meet and you see all these random folk, cousins, uncles that you might have very infrequent interactions with, and you start to talk to them about what's happened in the last 2 years. And it's like life has changed dramatically for so many people: marriages, births, deaths, disability, just
divorce
3 or 4 times. Yeah, lost a job, started a new one. And so much happens in life in such a quick period of time. And all of that has a real potential to change things. Somebody that you really trusted to handle your kids 2 years ago, maybe now you don't. Or, maybe you still trust them, but their life has changed so dramatically you don't think that they could, So that's always something to be thoughtful about, is like just thinking, like, what's changed in my life in the last year maybe that might have an effect on things. And so, yeah, I think it's great. Like, definitely designated beneficiaries are an easy one to check on. And so definitely want to take time to do that. Well, we're at our hour mark. And I hope that this has been enlightening and helpful to folk. Certainly, Kate and I just get a thrill about talking about this stuff, and we could talk about it for a really long time. And so that's one of the benefits of having a professional like Kate, that you can pull her aside, have a conversation, think through your particular circumstances. She's not going to get tired talking about it, right? and so we can be a benefit and a help to you when you need it. So please don't hesitate to reach out to either one of us if something has spurred in your mind today and listening to this little webinar that we might be able to assist with. Yeah, Kate, any other last comments or thoughts?
No, I think that's good. Like you said, if you have any questions, feel free to reach out. I'd be glad to help you out with any questions you have.
Very good. Well, everybody, with that, I will sign us off. Take care. Thank you so much.
Thanks.